Welcome to yet another episode of In Chambers with Mohammed Muigai. I'll be your host, Biko Angwenyi. Our guest for this episode is Mr. Guto Mogere. Karibu sana.
Thank you. I'm Guto Mogere. I head the dispute resolution group here at Mohammed Muigai.
Thank you. It's an honor and a privilege to have you here with us today. And I think we'll get cracking straight away. Guto, when did you decide you wanted to pursue a career in law?
Good question. I made that decision when I was in high school as a teenager. The idea of pursuing a career in law was suggested to me very strongly by a teacher. She was called Claire Mabachi, who was teaching me business and economics, and she thought, and history as well. And she thought that I'd probably be interested, or I'd find it fascinating to go and look at what a career in law looks like. And so she said that she'd try and organize to get an internship in the middle of the school holidays, which I was very lucky to do at a very young age. I think I was 15 years old or 16 years old. And it was here at Mohammed Muigai.
Oh. So that's where your journey in this career, you'd say, started?
Yes, I think that's when it started. It started earlier than the careers of most people, because I spent from that time onwards almost every holiday in chambers as an intern, long before I went to law school. And I also didn't consider any other career.
That was it.
That was it.
You mentioned going to law school. Where do you proceed to law school after spending some time here in Chambers?
I went to UK. I did my university degree there, and then in Manchester, and I came straight back to Mohammed Muigai again as soon as the degree was completed, and then began another internship and then pupilage.
So you took your pupilage at the farm as well?
Correct. Yes, I was a pupil of the great Professor Guto Mogere, senior counsel, who had been effectively my pupil master since I was a teenager. I'd be carrying his briefcase for all those years, and then now came to the pupilage program, formally as his pupil.
How was that pupilage experience? I know you had already been used to the work experience here at Mohammed Muigai. But that particular 6 months experience, if it was 6 months at the time, how was that particular experience?
I remember it being a lot longer than 6 months. For some reason, the pupilage then was quite long. It was at least a year. And very intense, very demanding. It was a lot of work. The Professor Muigai has very high standards, and he expects you to meet them. And so you have to learn quickly, and you have to put in a lot of difficult hours. But it was also a time that I really, really enjoyed. I was working with other pupils, and we became good friends and developed also good professional relationships. And I was not just working with Prof, but there were other advocates in the law firm who inspired me a lot and taught me a lot. People who have very, very good reputations in the profession, and I was lucky enough to be acquainted with them from a very early age.
I remember a few names that you...
Oh, very many, including the late Justice David Majanja. I worked very closely with him. People like Elisha Ongoya, who people see doing very well and doing very big cases. He's a very clever man. People like Crispin Odhiambo, our managing partner Jeffrey Mende, of course Mohammed Muigai, who worked with him. Later on with people like Prutas Sainde, Joanne Mutabari, yes, Pauletta Ching. There's a very big group of, then they were all young advocates, but very formidable advocates as well.
Sounds like it was a great experience.
It was. I wouldn't exchange it for anything.
Having been at the firm for quite a while since then, before Pupilage onwards, do you think the training experience and how it's conducted has changed any bit?
Yes, I think it has had to. There are things which have changed in the profession. Of course, there's technology, which was not that big a factor as it is today. And then there are also other ways of people relating to people which have changed. There's better awareness, I think, about mental health issues and mental health welfare. And the Pupilage program today considers that a bit more closely and a bit more carefully. At that time, you're being treated as an adult who doesn't know anything. So, yeah. So it was not the some of the responses to mistakes were not as carefully thought through as they are right now. Not as considerate.
Does it surprise you sometimes?
It surprises me to see that some of our people have mellowed, which is very good. But I think, we all get better by developing a better awareness of what it takes to train a young person and to induct them into a very demanding professional environment, but also to show concern and to understand and to be sensitive about the concerns that they may have. A lot of the discussions which I had with pupils today would not have been possible when I was doing my pupilage. Yeah,
I guess we've made some significant progress towards.
I think so. I think progress is the correct word. Yes, progress would be the correct way of describing it in a number of the different facets. Yeah.
What is the intensity still the same?
The intensity has to be the same if it's not higher, because the work ultimately still must be done, and the person has to be developed from whatever they are into a professional, and they have to be the sort of professional who can meet the demands of our own clients, which are high. So the intensity is not negotiable, and anybody who's done a pupilage here will tell you that it's an intense experience, but rewarding as well.
Tell me, after pupilage, when do you get called to the bar?
In early 2008, February of 2008. Yes.
And throughout this journey to end up as the head of dispute resolution, what drew you towards dispute resolution and litigation?
Good question. Again, what drew me is a number of things. One is the people who were in litigation. People like Prof. and Mohammed and Crispin and Imende and Justice Majanja. That was one. I admired these people and I looked up to them and saw them as role models and wanted to do what they were doing. But the other thing is I liked the litigation itself. I thought as that aspect of law fascinated me because of its ups and downs, its emotional, is it a roller coaster? You have your victories, you have your defeats. And it felt to me a lot like sport, which I had enjoyed in school and still enjoy. There's a lot of strategizing, there's a lot of going forward and retreating and learning how to deal with loss when you weren't expecting it. Same with learning how to deal with a victory which wasn't expected and how to regulate your emotions through all that. I quite enjoyed that.
That's quite interesting. I thought you were going to say you just like disputes through and through.
No, so I'm actually at heart not a combative person at all. Not at all. Yeah.
I think I can attest to that.
I'm not at all. Strangely enough, I mean, I hardly ever get angry, and I am not. I hardly ever find myself in a situation which I would call a quarrel, but I do enjoy the resolution of disputes, of which litigation is a part. And when we're talking about dispute resolution, the focus is on resolution, not disputing. No, not disputing. Yeah.
You've been called to the bar. Do you remember your first court appearance?
As an advocate?
As an advocate.
Oh, yes. The very same day. I was assigned by Justice Majanja. He called me and asked, have you done the thing? I said, yes, it's done. Okay, then you're needed at Milemani at 2:30 or whatever it was. But it was the very same day. And he insisted that you hit the ground running.
That's quite interesting. You did not proceed to start gathering people for soda and...
No. I think that's something which I think I don't think too many people were doing that that time. It would have been seen as, I don't know, a bit strange. What are you celebrating? There was an exam. You were supposed to pass it. You've passed it. Yeah.
As well we expect.
It's what we expected you to be doing. This is where we expected you to be. So, let's take a quick photograph and get on with life.
Start working.
Is
there anything memorable about that first appearance that you remember?
No, maybe just the surprise that being called to go to the magistrate's court the same day to argue some certificate. But it was a quiet afternoon. I remember it quite well. It was a quiet afternoon, just trying to get some ex parte order, which was refused. But it didn't dampen my spirit. I was very happy to be in the room and to be able to address the court.
Don't discourage you from continuing on this.
No. I did mention to the magistrate that this is my first appearance. I thought it might help, but it didn't.
Maybe
I was what made it worse. I think so. If I was hoping for leniency, I was misguided.
What about your first trial?
Trial?
Yeah, the first trial. The first time you had to cross-examine a witness and go through the motions of a trial process.
That I remember also very vividly. I don't think anybody who's been into trials will forget the first time they've had to go through that experience. And I went into it unassisted, which added to the nervousness of the situation. And against, on the other side was quite a senior lawyer, Chacha Odera, who is a very senior lawyer, a very prominent lawyer, and he was appearing with somebody else. But I got through, and he was also very, very kind. And he told me, just calm down, I think you're doing a good job, and just keep going. And the outcome, surprisingly enough, was in our client's favor.
Oh, amazing.
And we often talk about it. I told him, you helped me in my first trial and you are my opponent. And we became very good friends, and we have remained good friends from then until today.
You mentioned you were a bit nervous.
I was very nervous, and who wouldn't be? Who wouldn't be? You don't know anything about controlling a witness. What you know is what you've read and what you've been told, but there's none of that is the same as experience.
Yeah.
No, none of it comes close to actual experience. And because you know that in advance, you know that all this, I've never done this before, then you have to be nervous. You have to be nervous.
At what point in your career, if it happened, did you stop getting nervous ahead of a trial or an appeal, whatever it would be?
I didn't say that. I didn't say that there's a time I stopped getting nervous.
I presume that a time...
No. I didn't say that. I'd say the nerves are not what they used to be, but I wouldn't say that there's a date I can point at and that this is the day I stopped getting nervous. I don't think that day has actually come, but you learn to control the nerves, and mainly with the quality of your preparation, which I think is one of the things that improves as you gain a bit of experience and the profession.
No, that's very encouraging to hear. I thought I was still on this journey because I still get nervous. I thought I'm late, and now at least I know it was.
But are you getting better at fighting or controlling the nerves?
Yeah, it's getting better.
Okay,
definitely getting better than it was when I started.
And to be honest, I don't think there's something too bad about being nervous. I think being nervous keeps you on your toes because you have more to think about and you want to be as well prepared as you possibly can be. And I think if that's what nerves produce, then it's not something to fear or to regret. In fact, the opposite might be true, that overconfidence might breed some complacency.
Yeah.
And then you don't prepare as well because you think, I know it. And we've seen that before, where people come in and they haven't prepared. And it's possible that the reason they're not so well prepared is they've taken things for granted.
I do agree with you to that extent. Like every time you approach a case, it's like a pre-test. It's as if you're going for an examination.
Yes.
And you don't just sit back and wait to see the paper.
Correct.
Try and prepare
correct
for whatever questions the examiner has for you. So far, have you developed a preference between trials and appeals or arguing petitions where there are no witnesses, where it's just affidavits and legal arguments, or do you do both and enjoy both in equal measure?
I do both. I do trials and I do appeals. I enjoy both, and there are reasons to enjoy each, and those reasons will be different. With trials, I don't know, for some reason I find that I feel like I have an advantage.
Yeah.
Because it's a bit more, you're given a bit more room to make your point in trials, and increasingly I see the senior most advocates retreating from trials. So there's a lot of space there, which it has been created by them or by whoever. There's a lot of space there to excel if you're good at it. So I enjoy that. Appeals are also a good challenge. You have to think carefully about what is the point of law, what's the best way of presenting it, what's the most compelling presentation, the most compelling argument that can be said of this point. But you're not given as much time these days in appeals, so all the work is done in the back office, in the written submissions, and the part that's less is the oral advocacy. And that's one of the reasons you want to be a lawyer, or an advocate at least, is to go up and say who you are and say what your point is and make it.
And why you think it's the best way.
And why you think it's the best point, exactly.
And do you think with the growing trend towards written submissions, do you think there is risk that we find ourselves in an area of practice or a time of practice where we don't get to enjoy nice oral advocacy or try to?
Well, it has happened since, especially since COVID, or it was starting to happen. The written submissions were increasingly being relied on more than oral advocacy, and this predates COVID, but it was accelerated by COVID and the use of the online court hearings. But you have these meetings with the judges and with other advocates, and everybody wants to return to court. Yeah, a bit of it is nostalgia, and a bit of it is that there is something that's lost in the quality of advocacy if the person is not in the room with you. So I don't think there'll be a time it will be completely lost. I think the time is soon coming when there'll be calls for how do we balance between what we're doing online and what we can do in open court.
And that would be great. You mentioned how COVID robbed us of a bit of oral advocacy. What else do you think it really took away from the general practice of litigation?
I think, and other people have probably expressed this better than me. There's the camaraderie in the profession. People would have their case and go and have a cup of tea. And there's really no substitute for that, because there's so much you can achieve when you develop an informal relationship with somebody. You can settle cases which you thought too difficult. And today, when you watch cases online, people can fight about anything because they just don't know each other.
Mm-hmm.
And I think knowing each other would help with some of those situations. But also the mentoring aspect. For the younger lawyers especially, at least I owe a lot of what I learned to being in court and watching cases and watching advocates who are in cases which had nothing to do with anything that this law firm was doing. And I think that helped. And a lot of other people were learning the same way. So you could learn, you didn't have to have the best pupil master, but if you could watch him 4 or 5 times a week, you're learning. And if you could do that with many different people, you learn quite a bit. Now, so much of it is disposed of online. You lose a little bit of that opportunity to learn by observing.
And also learn what not to do.
Especially that. And I think that's even more important than learning how to do it.
Tell me something. What are your preparation methods now? Having done litigation for quite a bit of time, what are your preparation methods? Do they vary when you're preparing for a trial? Do they vary when you're preparing for an appeal? How is it like a week before a trial, to say?
Well, it will depend, I think, sometimes on at what stage I've been brought in or I've been instructed in a case. Because sometimes you find yourself, it's already at an appeal.
Yeah.
Sometimes you're lucky to be there from the beginning and you're the one who's taken the instructions. But either way, the preparation method hasn't changed too much from day one till today, in the sense that I've always believed you need to first know the documents backwards and know them inside out. Know them better than your opponent, know them better than the witness who you're going to be examining, certainly know them better than the court. And then you'd have some sort of foundation to build your case. But if you don't have that, there's really nowhere you're going. Yeah.
What skills do you think we would advise a young litigator who's looking up and saying they want to one day present like Guto? He was better than me. Okay. They're just looking to ensure that they will become successful as a litigator, or at the very least be decent in their output, so that they're not the person people look at to say, don't do that. What skills would you think they should equip themselves with very early in their careers?
I mean, the question basically is, how do you learn?
Exactly.
And you learn by reading, you learn by observing, and you learn by asking questions, and then by practicing. And you don't stop that process. The material that you should be reading is there. These days, because of the internet, there's no excuse not to find out how are the best advocates preparing, what are their interests, what exercises their minds, what troubles them, how do they think about their cases, where have they given lectures on if it's advocacy or if it's a point of law, how have they come to where they have. So I think you have to have an intellectual curiosity, and you have to have an enthusiasm. You have to be fanatic is not the best word, but it's a word that can work, so that you're trying as much as possible, given the natural gifts that you have, to develop those into becoming the best possible advocate that those natural gifts will permit. And if you do that, I don't think there's really a ceiling. It's a skill that can be learned. I don't think anyone is born with it. It's a skill that you have to learn, but it can be learned.
Certainly, there are people you learn from yourself, and there are lawyers you look up to. Who would this be? Yes, for yourself. What material do you consume, and from who? Who do you consider at least the best three?
I wouldn't name. I wouldn't answer it that way.
Yeah.
I will say that there are people I've been looking up to throughout my career, and for different things. Some it might be in an area of law. You say that somebody is very good at judicial review. Somebody is very good at criminal law. Somebody is good at commercial. Somebody is good at just general appellate advocacy or public law, whatever it is. I've tried to follow and be inspired by these people who've excelled in their very different fields. But the one thing which I've always admired is good advocacy, regardless of the field, even if it's not a field in which I have any particular interest. Good advocacy, I can't consume enough of it. So I'll always try and find out what is the good advocate of the day doing, what's the case that they're handling, and try and observe as closely as possible. A lot of it you'll find online, you can watch it. And not just here, but all over the world. So I enjoy that. I enjoy that thoroughly.
That's great. What has been the most rewarding part of the career so far? Not saying it's at its peak, but it's about 15, 16 years in now?
Thereabouts.
In those few years, what has been the most rewarding part of it?
It's always the contribution that you're able to make towards solving a problem that somebody had, and that feeling for me never goes away. That somebody came with a problem which they thought was a very serious problem, and as you grow in your career, the problems become actually more and more serious that you're given the privilege to help resolve. And when you see how this person reacts, or this institution reacts when you've helped them solve that problem, I find that a reward that I'd not exchange for anything.
Not even money.
It's. I mean, the truth is the legal profession is a financially rewarding one, as long as you're patient, and you do the right things. If you're growing your skill, the financial rewards will come. But if the financial reward is the only reason you're doing it, then you probably won't get out of it what you want.
That's nice. The courtroom, the office, work generally, very taxing. What do you do to relax your mind other than, resolving other people's disputes?
I don't resolve other people's disputes to relax my mind, but outside the practice, I am a golfer. I like to play chess. Play chess even here in the office with the other team members. I like to read when I can. I like to write. Sometimes I write for this is small articles here and there. And then that's as much time as there is for relaxing. Then we are back to work.
What are you currently reading, Mr. Guto?
Right now I'm reading a book about General Augusto Pinochet, and there's an account that has been written which came out just about a month ago of his arrest and extradition proceedings in the courts in England, and I find that quite a very interesting book. A very nice take on international law questions as well. So I'm enjoying that at the moment.
Yeah. Thank you very much. We'll end it at that point.
Thank you.
Release you, it being a Thursday evening,
Thank you.
so that you can relax your mind.
Thank you so much.
Thank you for joining us for that episode of In Chambers with Mohammed Muigai. You can find us on YouTube and Spotify for this and many other episodes.